morning everyone, I am Sayed Ruhi, a volunteer of AFRS. The topic today we are going to discuss is about forensics experts' opinion as per the new sections. In this session, we are going to discuss introduction. In introduction, we are going to discuss what is a forensic expert and how that opinion is important and duties and responsibilities and legal provisions which are given for the forensic expert's opinion. And third, what are the changes we have seen in new law and the old law, and lastly conclusion. Firstly, introduction. So let's see how we can define a forensic expert in normal words. The forensic expert is the only person who can legally do the experiments on the evidence related to a criminal case and present the findings in the form of report or testimony if needed in the court. This opinion of the forensic expert, which should be impartial, honesty and with integrity, helps the court and jury to make the decision regarding the case. This also helps the court to find the person is guilty or an innocent. Now let's discuss some roles and responsibilities of a forensic expert. Firstly, analyze evidences which are related to the case. Secondly, provide the technical expertise. The forensic expert should give their findings to the court in the form of report and testimony and help the court for better understanding of the examination results. Thirdly, present reliable findings. Their opinion should be impartial and unbiased and related to the issue or the fact disputed in the case. Fourthly, support legal cases. The opinion should be like clearing the doubts and issues regarding their findings in the court. Lastly, maintain integrity. It is the most important thing. The opinion should be honest and also ethical, which should be helpful for the delivery of the justice. These are the 5 main responsibilities a forensic expert should be follow while giving a report or testimony in the court. So now let's discuss some legal provisions which are provided for the forensic expert's opinion according to our old law of India. We have 2 of them. Firstly, Section 45 of Indian Evidence Act 1872. It says that when the court has to form an opinion upon a point of foreign law or science or the education which is out of court, she can take the opinion of the person who are specially skilled in that form, and that person is called as experts. And second one, we have Section 293 of CrPC 1973. According to this section, a central government scientific expert's report can be used as evidence in legal proceedings, and he can also summon for clarification of that report. And if that person is not available, behalf of them, a skilled person can also appear. Now let's discuss legal provisions according to the new law of 2023. In 2023, the IPC, CrPC and Indian Evidence Act has been replaced by Bharatiya Nyaya Sanhita, Bharatiya Nagarika Suraksha Sanhita and Bharatiya Sakshya Adhiniyam. It is to form the modernized legal system for the modern evolution. And we have following sections. Firstly, the Section 39 of BSA, which is similar to the Section 45 of Indian Evidence Act as we discussed before. And secondly, the Section 329 of BNSS, which is similar to the Section 293 of CrPC as we discussed before. Other than those sections, according to the Indian's new law, we have following sections too. Section 328 of BNSS. It says that a report from gazetted officers, like from forensic labs or mint print pressing, can be used as evidence without requiring the presence in the court. The court may summon them for the clarification, but cannot demand records used in the reports. Officer cannot disclose their unpublished records which they used in the test. If the requirement is necessary, they can take permission from the head department and ensure the confidentiality. And other section we have Section 330 of BNSS. It says that when the documents are filed, there should be prepared a list before, and both parties should admit or deny their genuineness within the 30 days. And the expert's witness is only called if the certain document is presented in the disputed issue, and the remaining undisputed documents are accepted as the evidences. So now let's discuss some major changes we have seen in new law and old law of India regarding the forensic expert's opinion. In old law, we have seen that only central government experts are allowed to present the opinion in the court, and there was no time limit for admitting and denying the document, which causes the more time consumption of the court. And thirdly, expert testimony was unrestricted. There were no such restrictions for the expert's opinion when or how to present in the court. And in new law, we can see there was a permission for all the certified experts of forensic science which are from central, state and private. And there was 30 days time limit for the document admission, which can cause the less time consumption of the court. And expert opinion can only taken if the reports are disputed. This was mentioned in the section 330 of BNSS, according we discussed before. By overall, we can say that the new law of India regarding forensic experts' opinion have set some new changes which helps in maintaining confidentiality and also maintaining the time of the court. By setting the rules like expert opinion can be used without the officers present. Court can summon officers but do not demand records. Officer need approval to disclose unpublished details. Parties must deny and admit document genuineness within the 30 days. And court can also extend the deadline with justification. Experts are only called if the report is disputed and undisputed documents accepted as the evidences. Lastly, conclusion. We can conclude that the new law of India regarding the forensic expert opinion has concentrated on the quick solving of case with more efficiency and aim to the victim-centric justice delivery method. Thank you for listening to a session on forensic experts' opinion as per the new law. I hope this session was useful and have a nice day.